Hello all, we'll continue with our discussion of previous year questions from the subject polity. The idea of the entire series is to cover the last 15 years of question paper, especially with regard to the polity subject. Before this series, we have done a series on 100 most important topics for prelims 2023 from the subject polity, which covers most of the important current topics and also the most of the important conventional topics in polity. So, after that particular series, we also thought to help the students better, we also wanted to do the last 15 years of previous year questions. So, that is the idea behind this particular session. So, to get the maximum benefit, try to watch both the videos, and I would also suggest that before watching these videos, it is better that if you revise your polity subject, and then once you revise and start watching these videos, it will be a full-fledged revision before you can go to the preliminary examination. Okay. So, with this introduction, we will directly get into the question. But before we get into the question, I would like to reiterate, as we have seen in the first class, that if you look into the subject polity, there are only 7 to 8 major themes. 80 to 90% of the questions are going to come only from these themes, and that has been repeated over a number of years. We have made a lot of analysis, you can also see it for yourself. The questions are going to come majorly from the philosophical part, which we have started discussing in the last class. The philosophical part includes the fundamental rights, DPSP, fundamental duties, directive principles of state policy, and the preamble to the Constitution of India. And then the next set of questions is going to come from the various system of governments, which includes the various themes like the federal provisions, separation of powers, and the other related aspect. Then the executive is an important topic, judiciary is an important topic, legislature is an important topic, local bodies is an important topic, constitutional and statutory bodies is an important topic, and then the other miscellaneous topic. So, in the last class, we have started our discussion with the first topic, that is the philosophical part, and we have covered few questions. So, we will continue from that particular area in this particular class, and once we are done with this particular philosophical part, then we will move on to the next important thing. So, the objective of this particular class is we will try to cover the philosophical part. Now, once we are done with the philosophical part, we will deal with the system of governments in the next class. Okay. So, we will just continue with where we are left in the last class. The last class we have covered the first 15 questions. Now, we will just continue from there. The next question in the series of discussion is the preamble to the Constitution of India. So, the question is about the preamble. The preamble to the Constitution of India, option A, part of the Constitution but has no legal effect. Not a part of the Constitution and has no legal effect. So, when you say it is not a part of the Constitution, you can directly eliminate this particular thing, because the Supreme Court has very categorically said in the Keshavananda Bharati case that the preamble is an integral part of the Constitution. The earlier view of the Supreme Court in the Babu Union case was that the preamble was not part of the Constitution, but that is no longer the case. So, you can eliminate this particular statement. Statement C, part of the Constitution but has the same legal effect as that of any of the other parts. So, this is also not true, because you also know that the preamble is integral part of the Constitution, but the preamble is not justiciable. The preamble per se cannot be enforced in a court of law. So, this particular statement is also wrong. So, these two things are very clear, but the confusion could be between statement A and the statement D. So, let us look into the statements again. Statement A is saying it is part of the Constitution but has no legal effect. So, definitely the statement that is given in statement A is true, but we will have to see which statement gives more information about the preamble. Any statement which is giving more information, that would be the most appropriate answer. Sometimes even if the statements are true, we will have to choose the most appropriate answer. See statement A, it is part of the Constitution but has no legal effect, which means it is part of the Constitution and nothing flows out of the preamble, nothing or any of the organs of the state does not derive their powers just because it is mentioned in the Constitution. So, that is the idea of it, it cannot be enforced per se. That is what it is saying. But what option D is saying, please understand, it is part of the Constitution but has no legal effect independently of the other provisions of the Constitution or independently of the other parts, which means it is also trying to give an extra information. The preamble in itself is not justiciable, the preamble in itself does not give powers to any of the organs of the state, but an additional information is also giving that the preamble, what is the purpose of this particular preamble? The purpose of the preamble is to interpret the other provisions of the constitution, and that's why we know that the preamble is also been told by the Supreme Court that it is a key to unravel the minds of the makers of the constitution. So this option is trying to explain that if there is any ambiguity with regard to any of the provisions of the constitution, the preamble can be used, and the preamble can be used to enforce those provisions and to interpret those provisions. So this option D gives the best possible information about the preamble in this particular question. So the right answer would be option D. Now please understand, preamble is a very small topic, but every year it is asked in the examination. So you should know each and every word that is given in the preamble. So whatever is given in the preamble, each and every word, and in the right order, you should be aware of what is given in the preamble. And not only that, you should be aware of that, you should be aware of the 42nd Constitutional Amendment Act 1976, which has inserted 3 words into the preamble, that is the socialist, secular, and the word integrity. Preamble is an integral part of the constitution in the case of Ananda Bharati case. Can the preamble be amended? Yes, of course it can be amended. Can it be amended in totality? The Supreme Court said that the doctrine of basic structure would apply even to the preamble. That means you can amend the preamble without amending whatever constitutes the basic structure of the preamble. So just have all these basic information, you can solve any question that comes from preamble. Let's move to the next question quickly. See the next question. With reference to the provisions contained in part 4 of the Constitution of India, which of the following statement the principles laid down in this part are to influence the making of laws by the state. So this is also very true. It is an obligation. When I say obligation, moral obligation. You see a number of laws in this particular country, they are all to give effect to various principles of directive principles of state policy. Each and every law you can one way or the other related to the directives. Okay. So this is very much true. So which of the statements or select the correct answers using the codes given below. So, the correct code would be option 2 and 3 only. So, that means it would be option D. Let us move to the next question. In the context of Indian polity, which one of the following would you accept as the most appropriate expression of liberty? Now, please understand, these topics in the recent past have become very, very important. The topics like liberty, the concept of justice, secularism, equality. So, you should have the understanding, clear understanding of these words to answer these questions. Come to the question. In the context of polity, which one of the following would you accept as the appropriate definition of liberty? So, to answer this particular question, first of all, we will have to understand what does it mean by the word liberty. And sometimes you also use the word freedom. And sometimes they both are interchangeably used, but please understand these two concepts are not the same. So, what does it mean by liberty and what does it mean by freedom? So, please understand, freedom is something that is unrestrained. It is unrestrained, there is no restriction upon what an individual can do. That is basically what is called as freedom. Giving freedom to individual is important. Then only the individuals can develop themselves, the individuals can think and do a lot of things which would help them in various aspects of their development, their moral, philosophical, intellectual, physical development and all those things. But at the same time, freedom is very dangerous. Anything that is unrestricted is that the individual can engage in certain activities which can harm others in the society. So, this is also basically called by the principle harm principle. But however, what does it mean? That the individual can engage in two types of harms. One is self-harming actions and harming others in the society. So, the idea of freedom is dangerous because in the name of freedom, people can engage in activities which may harm others in the society. So, in order to balance between these two things, on the one hand, you need to give the liberty. On the other hand, you will have to what? You will have to also protect the public good. You will have to protect the welfare of the entire society. So, they thought the best thing that they would give was liberty rather than what is called as freedom. So, how liberty is different from the word freedom? You can say liberty is nothing but freedom with restrictions. Freedom with restrictions, and these restrictions would be a reasonable restrictions. So, that is basically what is called as liberty. So, liberty means liberty also comes with certain set of freedom to an individual, but that freedom is not unrestricted. It is restricted. It comes with a reasonable restriction. So, this is what basically we will have to understand by the word liberty. Now, liberty is what is guaranteed to the citizens of our country. Why liberty is guaranteed? Because liberty always comes with reasonable restrictions. So, let me just take an example. Now, take the example of right to freedom of religion. So, there is a freedom of religion. Although the word freedom is used, this right to freedom of religion is not absolute in character. It comes with a lot of restriction. So, for example, the right to freedom of religion says that the individual have the right to practice, propagate, and also they have the right to practice and they have the right to profess and to propagate the religion. Okay, so they also have the right to propagate. Now, in the name of profess and propagate, is it possible for an individual to convert an individual from one religion to another religion by any means, including the force? Let us assume people are trying to use the coercive force and trying to convert people from one religion to another religion. Will it not create problem in this particular society? And that is why the constitution on the one hand gives them the right to freedom of religion, but on the other hand, it is not absolute in character. It can be reasonably restricted. It can be reasonably restricted on the grounds of public order, health and morality. So, this is what is the concept of liberty. So, liberty always comes with restriction. That means on the one hand, you are free to do certain things, but that is not that it cannot be restrained. It can be restrained and it can be restrained reasonably. That is basically what is called as liberty. So, with this information, come to this particular question. So, come to option B first, absence of restraint. So, liberty means there is always restraint. So, you can directly eliminate this. Opportunity to do whatever one likes. It is not something which is unrestrained. Opportunity to do whatever one wants means there is no restriction upon it. So, that is not the concept of liberty. So, you can be little confused between option A or option B, option A or option D. But however, the most appropriate answer is option D. Why that is option D? For which you'll have to understand the rights is further. So whatever the claim that we have, rights is nothing but the claim we have, which we exercise through the liberty that we have. Now the rights can be further divided into claim rights, and there is something which is called as the liberty rights. So what is liberty rights and claim rights? So claim rights means that it provides certain rights to an individual which shall not be taken away by the other individuals. The others shall not unnecessarily take it away. Okay. So please understand, protection against the tyranny of political leaders is in the form of claim rights. Say for example, there shall be no arbitrary detention. That's of course a right, but that is in the form of a claim right. But what is a liberty right? A liberty right is something, it is not about others taking it away from an individual, it is about what an individual can exercise himself. Say for example, right to freedom of speech and expression, right to freedom of religion. So it is not about others taking it away, it is about how an individual can exercise himself. So the most important answer for this particular question is opportunity to develop oneself fully. That means that essential amount of liberty will be given to an individual with reasonable restriction that would help an individual to develop himself fully. So that's the right answer. So try to understand all these concepts like justice, secularism, liberty, freedom. So this have also come to play an important role in deciding one or two questions in your examination. We'll move to the next question. Which article of the Constitution of India safeguards one's right to marry the person of one's choice? So this the Supreme Court has categorically said that it is implied under the right to life and liberty of an individual, that is Article 22. This was held by the Supreme Court in a case which is called as the Hadia case. Hadia case in 2018. So then it was a current affairs, and probably that is the reason the question was asked. So you don't have to worry about all these things, but what is very important is you will have to keep following the current affairs just during the time of examination. When I say during the time of examination, 1 year before the examination, you should be aware of the updated information with regard to any developments, with regard to any rights. So this is a very simple question. Come to the next question. The right to privacy is protected as an intrinsic part of right to life and personal liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statements? So again, this question was asked in the year 2018 preliminary examination, because in 2017 we know that the right to privacy was declared to be a fundamental right implied under Article 21 of the Constitution in a case which is called as Justice AS Puttaswamy case. Justice Puttaswamy case has filed a petition in the court, and he argued that there is something which is called as right to privacy, which is implied under Article 21. Then a constitutional bench of 9 judges were brought together, and then finally they agreed that yes, there exists something which is called as right to privacy, which is implied under Article 21 of the Constitution. And what was the reason that was given by the court? The reason that was given by the court is privacy is integral to the dignity. That means right to dignified life has already been recognized as a fundamental right implied under Article 21. And in this particular case, the Supreme Court was convinced that without privacy, an individual cannot exercise his dignity, an individual cannot protect his dignity, and hence right to privacy is implied under Article 21 of the Constitution. But at the same time, the court is of the opinion, like the other rights, this right can also be reasonably restricted. The state can restrict all those things subject to certain grounds like the national security and all those things. But however, to understand this particular right further, it is very important. Today we do not have a legal mechanism yet to protect our right to privacy, and that is why the Supreme Court has directed the government to bring in a legal framework to protect the right to privacy in our country, and which the government has tried to do by appointing a committee, and then subsequently they brought in the data protection bill. For some reason, now the government has withdrawn the previous version of the bill. I think now they are drafting the new version of the bill, which may be very soon introduced in the Parliament. The data protection bill that they will introduce may be relevant for your mains examination, but not very much for your preliminary examination per se, because the bill is not yet introduced in the houses of the Parliament. So you keep following all those things for the examination. So with this information, come to the statements. So this question is about right to privacy. See option A, Article 14 of the provision under the 42nd Constitutional Amendment Act, completely irrelevant. Article 14 is related to right to equality and nowhere related to the 42nd Constitutional Amendment Act. Article 17 and the directive principles of state policy. Article 17 is related to untouchability and DPSP related to part 4 of the Constitution. That is just a moral obligation. It is not related to a right. So that is also wrong. Article 21 and the freedom guaranteed in part 3 of the Constitution. So this is true. The right to life and liberty is under Article 21. So that is the right answer. Article 24 and the provisions under the 44th Constitutional Amendment Act. So this is also not wrong. Sorry, this is also not true. 24 is related to prohibition of child labor in our country, and the 44th Constitutional Amendment Act is nowhere related to the right to privacy. So the right answer would be option C. We'll move to the next question. Which of the following are regarded as the main features of rule of law? Very good question, a conceptual question. So to understand as to what is this rule of law, it's a very simple thing. What is rule of law? That means everything is governed in this particular country according to the law. Whatever the law says, it is how everything has to happen. Be it the prime minister, be it a poor farmer in this particular country, nobody is above the law and everybody has to happen according to the law. Anybody who commits an offense will be punished according to the law. So this is basically what is called as rule of law. Or to put it in a very simple way, rule of law means that there is no arbitrary exercise of power. So just remember this. There can be no arbitrary exercise of power because everything is done in accordance with the law of that particular country. And nobody is also above the law of that particular country. So this is the basic understanding you should have. But in order to ensure this rule of law and in order to ensure that there is no arbitrary action by the state, what are the basic things that you need to have in the constitution? The first thing is you need to limit the powers of the state. Now please understand, on the one hand you are saying that rule of law should exist, but let us assume that there is no limitation upon the powers of the government. Let us assume a government which is elected and the government is unrestricted and the government can do whatever they want to do. Do you think that they will respect the rule of law? Then the power can be abused and it can be misused. So one of the essential feature of rule of law is the government which is elected or whatever may be the government under the constitution of the respective country. The power of that government has to be restricted under the constitution. That is the most important thing. So there has to be limitation of powers. For example, how the power of the government is limited in our country, we have a fundamental rights which restrict the power of the state. We have the judiciary which can look into the actions of the state. So we do restrict the power of the state. So that is very, very essential to have rule of law. Statement 2, equality before law. Equality before law means everybody shall be treated equally in the eye of the law. So that is very true because which is what is the essence of Article 14 of the Constitution. So that is also important principle. People's responsibility to the government. Rule of law is nowhere related to the people's responsibility to the government. If you have to remotely connect this to what we have in the Constitution is the fundamental duties, and that fundamental duty is also just a moral obligation. It is no way related to the concept of what is called as rule of law. So you can safely eliminate this. Liberty and the civil rights. This is very, very important. Now this is again limited to the concept of the limitation of powers. How you can limit the powers of the state? By providing certain liberty and rights to the citizens. So liberty and rights are very much essential to protect the arbitrary action of the state and to ensure rule of law. So this is also true. So select the correct answers using the codes given below. So the right answer would be option 1, 2 and 4 only, that is option C. These philosophical understanding of the words like rule of law, liberty, justice, equality and also secularism is very important. We can expect definitely a question from this particular area. With this explanation, we will just quickly move to the next question. One of the implications, see, one of the implications of equality, the next question. One of the implications of equality in the society is absence of what? In fact, the very idea of providing Article 14 is to provide for right to equality. And without right to equality, there cannot be rule of law. So equality is a precondition to ensure what is called as rule of law. And what is the need to provide equal rights to all the people to prevent discrimination in the society? So please understand, one of the implications of equality in the society is absence of. That means when equality prevails, what will be absent in the society? That is what you'll have to understand. If equality prevails, do you think that there will be differences of ideologies? Now, India is a classic example. Please understand that India provides for right to equality as a fundamental right to all the people. But there are multiple ideologies in our country. There are multiple economic ideologies, political ideologies, and they equally thrive. And there's equal platform for everybody to thrive. So that means equality necessarily does not mean that there will be different ideologies, but it provides an equal ground everybody to develop and to follow whatever they want. Okay. So this is not the right answer. And again, equality means equal platform. That means everybody can equally compete with one another. So equality means there can be more competition rather than absence of competition. So you can also eliminate this particular thing. So our confusion could be between two things. One is restraints and other is the privileges. As I already said, please understand the constitution in our country, or for that matter in most of the countries, they give the rights to the people and they also ensure equality to the people. That doesn't mean that their rights cannot be restrained at any point of time. So please understand, right to equality means only equal treatment, and equally the rights of the people can be restricted. So that is also true. So equality doesn't mean that there are no restraints, because in fact in most of the democratic countries, people right comes with certain reasonable restrictions. So definitely equally the rights can be restrained. So equality doesn't mean that there are no restraints in the society. So this is also wrong, because anything that is unrestrained is dangerous. Just now we have seen. So it can come with restraints. So what would be the right answer? So whatever is left out is the privileges. So the answer is, one of the implications of equality in the society is absence of privileges. Now why it is very important, you will have to understand this. The very idea of bringing in equality is to prevent any form of discrimination in the society, to provide equal opportunities to everyone. And so please understand, the very idea or the essence of equality means it goes against the privileges. We do not want any specific privileged class. We want everybody to equally perform in this particular country, or at least you will have to give equal opportunities to all the people. But then the question is, do we not have any discrimination? Do we not have any special privileges to certain members of parliament? We have privileges to the president and the governors under Article 361. That is all fine. That are all exceptional principles. And these exceptional principles are allowed because that would help them to perform their duties effectively. And if they perform their duties effectively, it will again help the people of this particular country. Nothing more than that. It is a privilege to the office and not to an individual. Okay. So this is how we'll have to see this particular thing. So that is an exceptional case. But otherwise, the idea of equality in the society is to eliminate the privileges in the society. Very important question and an important concept. Come to the next question. Which principle among the following was added by the directive principles of state policy by the 42nd Constitutional Amendment Act? Now see, every year there is a question from DPSP. It's not a very difficult question to answer. In fact, a very simple question to answer. If at all you may find any difficulty in this philosophical part, you may get it with the fundamental rights, provided that if you are not having a proper conceptual understanding. Otherwise, you can get all the 100% questions right from this philosophical part, because they are not going to ask you something factual. It's very easy for you to answer all these things. Now, please understand, even if they ask you something factual, it is going to be something because you are reading it again and again, it automatically gets into your mind. Now, as I already said, the DPSP is part of what? It is part of part 4 of the Constitution. From Article 36 to Article 51, they deal with the directive principles of state policy. And if you see this directive principles of state policy, we already discussed that it is non-justiciable in character, and we have seen as to what is the reason as to why it was non-justiciable in character. And in addition to being non-justiciable in character, we have also seen that it is classified into different types. This DPSP was also amended certain times, and some of the most important amendments by which the DPSP was amended was the 42nd Amendment, the 44th Amendment, the 97th Amendment, and before that there was 86th Amendment. Okay. So also try to revise as to what amendments has happened by these constitutional amendments. This question is related to the 42nd Amendment. 42nd Amendment has inserted 3 directive principles. One is Article 39A, another is Article 43A, another is Article 48A. So it is related to free legal aid, free legal aid to the poor was added by this, and this 43A is related to participation of workers in management, and Article 48 is related to protection of environment and wildlife, that the state shall take measures for all these things. So, simultaneously you also revise what has happened or what was inserted by the 44th Constitutional Amendment Act in 1978, and the 97th Constitutional Amendment Act inserted cooperatives. 86th Constitutional Amendment Act inserted the childhood care of the early childhood care under Article 45. So, all these things very important. So, just try to remember these factual things also. This is also one of the important theme which is asked in the UPSC examination. In addition to this, you may also remember, sometimes this is also asked in UPSC, that sometimes they put across certain laws or certain schemes, and they ask you to correlate which of these schemes or which of these laws is related to directive principles of state policy. So, you should be in a position to correlate certain laws and schemes with the individual directive principles of state policy. One clue that you can use is, for most of these questions, the answer would be all of the above. Most of the times it is all of the above, 95% of the case, or even more than that, it is all of the above, but sometimes there can be an exception also. So, you will have to be a little careful about this particular thing when you solve it. So, with this information, come to the question: equal pay for equal work for both men and women. So, equal pay for equal work was not inserted. Participation of workers in the management, yes, of course it was inserted. Right to work, education, public assistance was not there. Securing living wage is not there. So, you also may look into the various amendments that has happened to the directive principles of state policy. So, the answer is option B, that is which was inserted by the 42nd Constitutional Amendment Act. Come to the next question: which one of the following statement is correct? So, what is the question is all about? The rights are claims of the state against the citizens. Rights are claims of the state against the citizens. In fact, the rights are not claims of the state. In fact, the rights are claims of the citizens against the state. The very idea of right which is given to the individual is to protect the individuals from any form of oppression by the state, any form of arbitrary action by the state. So, that is why we say that the rights are negative in character. Now, why do we say that the rights are negative in character? In fact, not all the rights are negative in character. We say it is negative in character because it puts some restriction upon the powers of the state. It restricts the powers of the state, and that is why we call the rights to be negative. There are certain rights which is positive in character also. Say for example, right to education is there, Article 21, which is not putting any restriction upon the powers of the state. Rather, it is asking the state to provide the right to education to all the child up to 14 years of age. But most of the rights, they are negative in character. So, when I say that it is negative in character, rights are restriction upon whom? It is restriction upon the powers of the state and not upon the individual. So, rights are claims of the state against a citizen. No, it is vice versa there rather. Rights are privileges which are incorporated in the constitution of the state. Rights are privileges which are incorporated in the constitution of the state. In fact, that is not the appropriate expression. So, what is the appropriate expression is rights are claims of the citizens against the state. It is privileges, but what is the need for this claim or entitlement? The rights is to prevent the arbitrary action of the state. So, option B, although looks a little right, it is not the exact expression of what is right. Rights are privileges of a few citizens against the many. No, that is not, at least we have in India. So, mostly the idea of right is you will have to give equal rights to all the people. So, it is not against many, rather it is against the state. So, the appropriate answer would be rights are claims of the citizens against the state. So, the right answer would be option C. Next question, consider the following statements. With reference to the Constitution of India, the directive principles of state policy constitutes the limitation upon. First statement, legislative function, executive function. What do you mean by legislative function? Legislative function means what kind of laws that can be made by the legislature. When I say the legislature, it can be both parliament as well as the state legislature. So, now the question is, does the directive principles of state policy, does it restrict the power of the parliament or the state legislature in making the laws? It does not restrict the power of the parliament or the state legislature. Why it does not restrict the power of the parliament or the state legislature? Because we know that the directive principles of state policy is non-justiciable in character. When you know that it is non-justiciable, then there is no kind of restriction upon the power of the parliament or the state legislature to make laws. Or in other words, that any law that is made by the parliament or by the state legislature cannot be challenged merely on the ground that it is violative of the directive principles of state policy. If they want, they can implement it. If they want, they can make any law, but it is just a moral obligation. So this is not a limitation. So this is not a limitation. Now the next thing is the executive functions. So what is an executive function? Whatever is carried out by the executive organ of the state, whatever is done by the government, whatever is done by the ministers or by the other executives, can their actions be found violative of the directive principles of state policy? No, because again the directive principles of state policy is non-justiciable in character. Now with this understanding, come to the particular question. Now most of the actions of the legislature and the executives are in line with DPSP. That is another thing, because they wanted to implement those directives so that it can lead to the welfare of the people, so that they will be in a better position to win the next elections, because in India there are regular and periodic elections. That's a different thing. But the directive principles of state policy is definitely no restriction upon the powers of the executive and the legislature. So which of the statements given above are correct? The answer would be neither one nor two. Both of them are not a limitation upon the powers of the state. Come to the next question. Which of the following statements is true of the fundamental duties of the Indian Constitution? So now the question is coming from the fundamental duties. Statement 1, a legislative process has been provided to enforce these duties. Statement 2, they are correlative to legal duties. So to answer this particular question, let us see few information. In fact, the fundamental duties are mentioned in part 4A of the Constitution, inserted by the 42nd Constitutional Amendment Act 1976, because before that we did not have fundamental duties. On the recommendation of the Swaran Singh Committee, it was Mr. Swaran Singh who recommended this, under which the Constitution was amended under the leadership of Prime Minister Indira Gandhi, and then the fundamental duties. So originally there were 10 duties. Today there are 11 duties, and the last one was added by the 86th Constitutional Amendment Act. So these are the few factual information that you should have. But however, please understand, similar to that of the directive principles of state policy, the fundamental duties are also non-justiciable in character. So this is very, very important. Are they justiciable in character? So fundamental duties are the duties which are to be performed by the citizens, but if the citizens do not perform any of these duties, then it cannot be enforced in a court of law per se, because it is non-justiciable in character. Now the second most important thing is the duties are only for the citizens, and it is not for the aliens. It is only for the citizens to perform these duties. So this is the basic understanding that you should have. With this, come to the first statement. A legislative process has been provided to enforce these duties. That means, is there a special procedure? Say for example, under the Constitution of India, there is a procedure to amend the Constitution. So similarly, is there a special procedure that is laid down in the Constitution to make any laws to enforce any of these duties? There is no special procedure, there is no special process for this. But however, please understand, in fact, if Parliament wanted to enforce any of these duties, they can enforce it. They can make a law and they can enforce it. But that is done just like an ordinary act. That is not that a special process has been laid down in the Constitution. In fact, today we have the Prevention of Insults to National Honours Act. Now under that we have a flag code. Somebody who is disrespecting the national flag or the national anthem can be punished. So which is also part of the fundamental duties. But it is not enforced just because it is there in fundamental duties. But we have a law. But there is no special procedure or a special process to make that particular law. So that particular statement is wrong. Statement 2. They are correlative to legal duties. They are not correlative to legal duties. That means, can they be legally enforced, these fundamental duties, if it is not performed? No, that is not possible. So this particular statement is also wrong. So which of the statements given above are correct? So or select the correct answer using the codes given below. The answer would be neither one nor two. So both the things are not true. We'll move to the next question. Which one of the following objectives is not embodied in the preamble? See, very simple question that you just have to know the words in the preamble. We already discussed what are the important things that you should know about the preamble. Let me just reiterate that once again, because only when you know this, you can be able to answer any question that comes from the preamble. So, first of all, you should know that the preamble is an introduction or a preface to the constitution. Then a question arose that whether the preamble is an integral part of the constitution or not. Initially, the court said, no, the preamble is not an integral part of the constitution. Then the court has revisited the same thing in the Keshavananda Bharati case. They said, yes, the preamble is an integral part of the constitution. But then what is the purpose of the preamble in the opinion of the courts? The purpose of the preamble is to unravel the minds of the makers of the constitution. That means the preamble is not giving any power to anyone or to any authority. What the preamble is merely doing, it is used as a guide to interpret the various provisions of the constitution wherever there is some kind of confusion or where there is some kind of ambiguity. So, that is what is the main purpose of the preamble. And because it is an integral part of the constitution, can it be amended? Yes, of course, it can be amended. 42nd Constitutional Amendment Act 1976, only once the preamble has been amended. Can any part of the preamble can be amended? The Supreme Court said that you can amend the preamble, but subject to the restriction of basic structure. That means anything that would consider to be part of the basic structure within the preamble cannot be amended. Say, for example, the words like democratic, the words like republic, they cannot be amended, which has been declared to be part of the basic structure. And then in addition to that, try to remember each and every word in the right order as it is given in the preamble, which is very, very important for your examination. Many times this single area has been asked in the examination. With this information, come to the following question. Which one of the following objective is not embodied in the preamble to the Constitution of India? The preamble to the Constitution of India talks about liberty of thought, expression, belief, faith and worship. Only these 5 things are given, but it is not talking about economic liberty. So, it is coming under economic, the word coming economic is coming under justice. In fact, you should also remember the word justice. So, justice is social, economic and political, and there was also a reason as to why they followed this social, economic and political, because the social justice is far more difficult to achieve than the economic justice, and the economic justice is far more difficult to achieve in relation to the political justice in the opinion of the Constituent Assembly, and that is why this particular order has been followed. So, which one of the following is not embodied? The right answer is option B. We will move to the next question quickly. So, all these things, see, very simple topics, simple questions, provided if you revise it properly and if you have the proper understanding of the things, you can answer 100% of the questions from the philosophical part. Question number 28. In the context of India, which one of the following is the correct relationship between the rights and the duties? What is the relationship between the rights and the duties? That is there, if at all, is there a relation between the rights and the duties? We know rights is there in part 3 of the Constitution, duties is there in part 4A of the Constitution, part 3, duties are there in part 4A of the Constitution. So, what exactly is the relation? One is justiciable in character, other is non-justiciable in character. Rights are justiciable, duties are non-justiciable. So, what exactly is the relation between them? So, let us try to understand. Come to statement number A, rights are correlative with duties. That means, is they related to duties? Is the rights related to duties? Is there any relation between the rights and the duties? We will just come back to that particular statement. But before that, rights are personal and hence independent of the society and duties. Rights are personal, but you cannot say that it is independent of the society. Whatever a right which is given to an individual, say for example, the right to freedom of speech and expression is there. But the way that you use your right is not independent of the society. You cannot go and engage in something which is called as a hate speech, which is going to create problem to the communal harmony in this particular society, and hence it is not independent of the society, okay, and also of your duties, because there is some kind of relation between the rights and duties. So, this particular statement is wrong. Rights, not duties, are important for the advancement of the personality of the citizens. There is no such interpretation in the Constitution. Although the rights has been given an important position because it is justiciable in nature, there is no such interpretation that the rights are important and not the duties. In fact, if the people are not performing their duties, probably not everybody will be able to exercise their rights in the first place. So, there is some kind of correlation between them, and hence this particular statement is also wrong. Duties, not rights, are important for the stability of the state. Again, there is no such interpretation nowhere in the constitution that the rights are more important for the stability of the state. Okay, so again you can eliminate this particular statement. So this is also an approach that you will have to follow in the examination. If you are not able to identify the right answer, go for the elimination approach. That's a reverse process that you have to follow. The elimination approach could help you in coming to the right answer. So now come to the statement A. What is statement A is saying? Statement A is saying that the rights are correlative with duties. Of course, they are correlative. Let me take an example of the right to education under Article 21A. Article 21A is saying that every child in the age of 6 to 14 years shall be given the education. So similarly, there is a corresponding duty in the fundamental duties, which is saying that it shall be the duty of the guardian or the parent to educate the child. So in this way, you can find some kind of correlation between the rights and the duties. So there exists some element of correlation, at least an implicit correlation between them. So the right answer is option A in this particular case. We'll move to the next question. Next question. The mind of the makers of the Constitution of India is reflected in which of the following? So this is what exactly the Supreme Court said. In fact, in the Berubar Union case also, and the same purpose for the preamble is also accepted in the Keshavananda Bharati case as well. So what is the purpose of the preamble? The minds of the makers of the Constitution is reflected in what? It is the preamble. In fact, the preamble is nothing but it is a key to unravel the minds of the makers of the Constitution. Any ambiguity in any of the provisions, we know that what is the summary of the Constitution, and by using this, we will try to interpret the other provisions of the Constitution. That is what is the purpose the preamble serves. The preamble is also summarize the entire philosophical part of the Constitution. It gives us as to what kind of value system are embedded in the Constitution. So all these things are the purpose behind the preamble. So the right answer is option A. Again, very, very important. So please understand, we are discussing the last 15 years of question, and at least I think 6-7 questions have come from the preamble, which means every second year there is a question from preamble, and a very simple question. So this is how we will have to identify the topics and prepare them one by one, so that you attempt 80 to 90% of the questions right. You don't have to get 100% of the questions. All that ultimately you need to clear the preliminary examination is that you need 50% of the marks. But try to maximize your score in certain areas where there is your strength. And of course, polity is one subject, everybody can understand this. It is not that you cannot understand once you read it. And the more you revise, the more you understand the concept, you can reach up to 95% questions or even 90% of the questions right. And thereby you can leverage it against any of the other areas where you have a weakness. Come to the next question. Which of the following are envisaged by the right against exploitation in the Constitution of India? So this we have already discussed, that there are 6 themes of fundamental rights, starting from right to equality from Article 14 to 18, and then we have the right to freedom under Article 19 to 22. Then we have the right against exploitation, that is under Article 23 and Article 24. So Article 23 and Article 24 talks about what? Right against exploitation, which talks about human trafficking, behar and all those things, and also against the child labor. So this is prohibition of child labor. What is unique about these fundamental rights? Please understand. Now you will understand most of the fundamental rights under the Constitution is only against the state. That means the state shall not do anything that would be violative of the fundamental right. But however, these fundamental rights are little exceptional, that it is not only against the action of the state, but it is also against the action of the private individuals. So neither the state nor the private individuals shall engage in the violation of these rights. In that case also, the remedy may be guaranteed to the individuals. And one similar article is also untouchability. In case of untouchability also, it is not only against the state, but it can also be against the private individuals. And in addition to the right to equality, the right to freedom, right against exploitation, then we have the next theme of fundamental rights, that is right to freedom of religion from Article 25 to Article 28. Then we have the cultural and educational rights for the minorities. Although Article 29 and Article 30 both talks about the rights of minorities, but if you look into the various judgments and the constitution carefully, it is only Article 30 that talks about the minorities. It deals with the rights of the minorities. Article 29, although it mentions the word minorities, but it is not only to the minorities, but it is for any section of citizens within the territory of India having a distinct language, script and culture. We will discuss that at a later stage if any question comes. And then the last theme of fundamental right, which is also considered to be the heart and soul of the constitution, in the opinion of Dr. B.R. Ambedkar, is the right to constitutional remedy under Article 32 of the Constitution. So, with this information, just come to this particular question. So, right against exploitation in the Constitution is dealing with 1. Prohibition of traffic in human being and forced labor. So, this is true, which is covered under Article 23. Abolition of untouchability, no, it comes under right to equality, but under Article 17. Protection of interest of minorities, yes, this is not under, this is a fundamental right, but under Article 29 and Article 30. And then we are left with the prohibition of employment of children in factories and mines. So, this is true. So, which of the following is are correct? So, the right answer would be option C. Now, what is the understanding you have? Now, the understanding that you should have is not only that you will remember what is right against exploitation from this particular question. What should be the takeaway from this particular question? You will have to understand as to what is the theme as to how they ask. Earlier, we have discussed a question that which of the following is under right to equality. So, probably there can be a question in the future which they ask which of the following falls under the right to freedom. So, that means the idea here is you should remember each and every fundamental right. Not only you will remember the fundamental rights, and you should also remember the fundamental right, a specific fundamental right falls under which theme, and that is very important. And also try to remember the articles for the fundamental rights. Sometimes that can also be asked. Next question. To uphold and protect the sovereignty and the integrity of India is a provision made in what? To uphold and protect the sovereignty and integrity of India is in the provision of what? So, this you will have to understand. So, where this particular thing is mentioned. So, definitely it is not there in the directive principles of state policy, nothing is there. Fundamental rights, nothing is there. So, if you look into the preamble, also the preamble talks about the sovereignty, the word sovereignty, it also talks about the unity and integrity of this particular country, but this is not the exact expression that is given in the preamble. So, the right answer for this is the fundamental duties. The fundamental duty, you can see that a specific article is there which talks about protecting and upholding the sovereignty and integrity of India. I think it is Article 51A subclause C. So, which talks about protecting the unity and integrity of India along with the sovereignty. Now, what should be the takeaway from this particular question? Again, they can give a list of fundamental duties and they can ask you to identify. So, they can give a list of statements where there are few fundamental rights or some directive principles of state policy and then a fundamental duty, and they can ask you to identify which of the following is a fundamental duty. So, the idea is any aspirant who is appearing for civil service examination, or generally also this is very basic thing, that we should be aware of what is a fundamental right, we should be aware of what is the directive principles of state policy, and we should be aware of what are fundamental duties. I am not saying that you understand the essence of these things, you should also independently know what are the rights, and you should be in a position to differentiate between a right and a fundamental duty, and a fundamental right and a duty in comparison that of a directive principles of state policy. So, this is a very important theme for your examination. Next question. The next question is the ideal of welfare state in the Constitution of India is enshrined in what? The ideal of welfare state is very much enshrined in the directive principles of state policy. Now, what is the reason why this directive principles of state policy is laid down in the Constitution? The very idea as to why these directives are put in the Constitution is to provide for a welfare state. Then the Constituent Assembly thought that this is a very nascent democracy, and now India has become independent, having its new constitution. It might have multiple challenges. So, the constitution itself should give some directives, so that if they start implementing these directives one by one, automatically it can lead to a welfare state. So, that is the idea behind these directive principles of state policy. Now, in fact, this directive principles of state policy is similar to that of instrument of instruction. It is similar to that of the instrument of instruction given in the Government of India Act 1935. So, try to remember this also. This may also be asked in the examination. So, we have discussed the other things relevant to the DPSP. So, I am not taking much of discussion in this particular question. So, we will go to the next question. And also similar to that of instrument of instruction, there is also something which is called as objectives resolution. So, objectives resolution is related to the preamble. Do not get confused between objectives resolution and instrument of instruction. I am repeating this again. Instrument of instruction is related to the DPSP and objectives resolution is related to the preamble. 13th December 1946, the objectives resolution was introduced in the Constituent Assembly by Pandit Jawaharlal Nehru. And what is this objectives resolution? It is a philosophical framework as to how the future constitution of India has to be. What are the values that it has to carry forward? And then later this objectives resolution was modified and it was placed as the preamble to the Constitution of India, which India has adopted and accepted, and it came into force on 26 January 1950. Come to the next question. In the Constitution of India, the promotion of international peace and security is included. So, this is exactly mentioned in Article 51 of the Constitution in the directive principles of state policy. So, please understand, this is what I was trying to say some time back, that you should be in a position to understand and you should be in a position to differentiate as to what are duties, what are rights, and what is directive principles of state policy. Very, very important theme. At least 4 or 5 questions which is related to this particular theme has been asked in the last 15 years. Very simple, very easy. Try to make this. So, definitely it is not related to the preamble, not related to fundamental duties, nowhere related to the 9th schedule of the Constitution. We have seen enough discussion with regard to the 9th schedule. So, I am not getting again into the 9th schedule of the Constitution. For more discussions and complete understanding of the 9th schedule, you can refer to the 100 most important topics which has already been recorded and it is there in the StudyIQ English channel. So, along with the previous year questions, it is also equally important that you also go through the 100 important topics for prelims 2023. So, which can give you a good hold before and it can really boost your confidence level before you go to the preliminary examination. It is going to take 10 to 15 hours of time, but I think that the time is worth enough investing before you go to the examination, because it is going to completely make you revise your polity subject. Come to the next question. A constitutional government is one. I think we have already discussed as to what is a constitutional government. A constitutional government is one which follows the principle of constitutionalism. And what do you mean by constitutionalism? Constitutionalism means that any government showing adherence to the principles laid down in the Constitution. In fact, there are certain terms which is called as the banana republics. A banana republics, or a country which has a constitution but there is no respect to the constitution. The constitution says something, but whatever is actually happening in that particular country is entirely different thing. So, there are also few neighboring countries in India which is going through such a turmoil, a political turmoil, where the constitution is saying something, but what actually happens is something. The countries are led by the armies rather than by the democratically elected government. So, such type of constitution, you can say that such type of countries are example where there is a constitution but there is no constitutionalism. So, what is constitutionalism? Constitutionalism, having a constitution in itself will not make that the country is having constitutionalism. What is constitutionalism? That when a particular government is carried out and all the institutions in a particular country follows or performs their functions in accordance with the principle laid down in the constitution. That is what is constitutionalism. So what exactly can lead to constitutionalism? The moment you come across the word a constitutional government or constitutionalism, majorly it has to prevent the arbitrary action of the state. If the state is too powerful, if the government is too powerful that they can do whatever they want to do rather than following what is there in the constitution, then there is no constitutionalism. So what is constitutionalism? What will lead to a constitutional government? Statement 1, places effective restrictions upon the individual liberty in the interest of the state. No. A constitutional government is something which places effective restriction upon the state on the interest of the people. If there is no restriction upon the powers of the state is so powerful it can deprive the rights of the people. So that is the understanding that you should have. So it places effective restriction upon the, not upon the individual's liberty, but rather on the state. So you can eliminate this particular statement. So what is the right answer in this particular case? It places effective restriction on the authority of the state in the interest of the individual liberty. So this is the right statement. Which of the statements given above are correct? So the correct answer would be option 2 only. We will quickly move to the next question. So all these concepts are very, very important for the examination. The economic justice as one of the objectives in the Indian constitution. So please understand, again a question from preamble, very, very important and easy thing. The economic justice. So we have seen that under the preamble, it talks about 3 types of justice. Justice in terms of social, economic and political. And we also seen as to why the social justice has been given more importance than the economic justice, and the economic justice more important than the political justice. So it is part of what? It is part of course, it is part of the preamble. So the preamble is just a summary of the constitution, and that means the idea of these things are already there in the constitution. So where else is this idea of economic justice is there in the constitution? It is very much there in the it is very much there in the directive principles of state policy. And where exactly in directive principles of state policy? It is very much mentioned in Article 39B and Article 39C. Very, very important articles under the constitution, Article 39B and Article 39C. Article 39B talks about the redistribution of wealth in the society. Article 39C talks about the prevention of concentration of wealth in the society. And both these articles are aimed at what? Both these articles are aimed at redistribution and the prevention of concentration. That means they are trying to come up with providing economic or equal economic opportunities to the people as far as possible, which is an idea related to the concept of economic justice. So which of the following would be the right answer? The right answer would be the preamble and the directive principles of state policy. That is option B. So this is the way that you will have to remember the things. Come to the next question. In fact, if you go to the previous question, Article 39B and Article 39C has been given so importance that a constitutional amendment was brought in, that is Article 31C, by the 25th Constitutional Amendment Act 1971, which has given protection to any law that is made by the legislature. And if that law, even if it is violative of Article 14 and Article 19, still they cannot be declared to be void. That is why it is also said that wherever Article 39B and Article 39C comes in, Article 14 and Article 19 goes out. This is to ensure the idea of justice. The constitution not only talks about equality, the constitution also gives equal importance to the concept of justice. It includes both social, economic as well as the political justice. Come to the next statement. Come to the next question. According to the Constitution of India, which of the following are the fundamental for the governance of the country? So what is fundamental for the governance of the country? It is these directives or the guidelines that is given in part 4 of the Constitution. So what is the right answer? What is fundamental for the governance? It is the directive principles of state policy. Although not justiciable, no government can ignore this. Why they cannot ignore this? Because they are fundamental in the governance, and if they do not follow this, then the people can vote them out of the power because of the periodic elections that we have in our country. So that's the basic understanding that you should have. Come to the next question. Which of the following is are among the fundamental duties laid in the Indian Constitution? 1. To preserve the rich heritage of our composite culture. So, which of the following is are laid down in the fundamental duties? As I already said, you should remember what is a fundamental duty. You should know all the 11 duties in your mind, or at least when you read them, you should be able to identify that this is a fundamental duty and not a fundamental right. And in case if it is a directive principles of state policy, you should be in a position to understand it is a DPSP. To preserve the rich heritage and composite culture, which is very much part of the fundamental duties. To protect the weaker sections from social injustice, I will just come to this. To develop scientific temper and the spirit of inquiry, yes, this is also part of it. To strive towards the excellence in all spheres of individual and collective activity. So, this is also a fundamental duty. But look into option B. Option B is not a fundamental, or statement 2 is not a fundamental duty. To protect the weaker sections from social injustice is an idea in the directive principles of state policy. So, it is related to DPSP and not the fundamental duty. So, which of the following is the right answer? So, the right answer would be option 1, 3 and 4 only, that is option C. So, I am not going to further discussion because I have already discussed enough with regard to the major themes of the directive principles of state policy. You should know it is non-justiciable, you should know the various amendments, you should know what are Gandhian, what are liberal and what are the intellectual, liberal intellectual and what are the socialistic principles. You should also know a list of laws that could be related to the directive principles of state policy and differentiate DPSP from the fundamental rights and fundamental duties. If you know this, you can definitely answer any question that comes from this particular topic. Come to the next question. Consider the following provisions under the directive principles of state policy as enshrined in the Constitution of India. So, again this question is related to the directive principles of state policy as it is enshrined in the Constitution of India. Securing for citizens of India an uniform civil code, yes, it is very much there under Article 44. Organizing village panchayat, so this is the first one is a liberal principle, this is a Gandhian principle. Protecting the cottage industries in rural areas, that is again the Gandhian principle. Securing for all workers a reasonable leisure and the cultural opportunities. So, this is also true, which is also there in the DPSP, but see the question, which of the following is or a Gandhian principle reflected in the directive principles of state policy. So, definitely uniform civil code is not there. UCC is a liberal principle. So, wherever there is one, you can just eliminate out. So, this is one way that you can go about if you are not sure as to what is the exact answer. So, this is again an elimination approach. You try to follow this elimination approach also. So, do not be overwhelmed when you do not know something or when you know something immediately and do not try to make a mistake. So, just have an element of patience and try to control your nerve a little bit and then you will be able to do it. Not only exactly in this particular question, this is a quite simple question, but you can apply the same thing to the other questions as well. So, the right answer would be option 2, 1, 3 only, that is organizing the village panchayat and the cottage industries. Well, all are DPSP, but the Gandhian principle is only under option B. We will move to the next question. Under the Constitution of India, which one of the following is not a fundamental duty? So, again see, very important question, which is not a fundamental duty. To develop a scientific temper is a fundamental duty. To safeguard public property is a fundamental duty. To abide by the Constitution and respect its ideals is a fundamental duty. To vote in public elections is not a fundamental duty. There is no such duty under this. So, which one of the following is not a fundamental duty? So, the right answer is option A. Option A is the right answer. Come to the next question. Consider the right to education, right to equal access to public service, right to food. Which of the above is or the human right or the human rights under the Universal Declaration of Human Rights? Under the Universal Declaration of Human Rights, India is a signatory to the Universal Declaration of Human Rights. So, if you look into this Universal Declaration of Human Rights, it has got a preamble for itself and it consists of article 1 to article 30, and with this we have already discussed. If you look into the preamble and article 1 to article 30, it is related to the preamble to the Constitution of India, whatever is given here. It has a relation to the preamble, it has a relation to the fundamental rights, it has a relation to the DPSP, it has a relation to the fundamental duties. So, if at all a question comes, what the Universal Declaration of Human Rights is related to, it is related to all the 4 things. So, just try to remember this. So, here come Right to education, right to equal access to public service. So, this is very much related to Article 21 of the United Nations Declaration of Human Rights. Right to food is mentioned under their Article 25 of the United Nations Declaration of Human Rights. Right to education is related to Article 26 of the United Nations Declaration of Human Rights. So, the idea is, if a question is being asked in such an area, do you have to remember the articles in the United Nations Declaration of Human Rights? No, not required. Just see that whatever is given has any relation to the preamble, if it has got any relation to the DPSP, if it has got a relation to the fundamental rights, if it has got any relation to the fundamental duties, most likely these provisions are there in the United Nations Declaration of Human Rights. This is one way of going about it, or another way is that you can go through these articles once, just have a fair idea in your mind as to what they deal with. That's also another way that you can go about it. So, what is the answer for this particular question? So, the answer would be option D. It consists of all the three things. That is 1, 2 and 3. Come to the next question. The instrument of instruction contained in the Government of India Act 1935, incorporated in the Constitution of India in the year 1950, is related to what? It is related to the directive principles of state policy. So, this is what I have been telling number of times. It is directly related to the directive principles of state policy, and the objectives resolution is related to the preamble to the Constitution of India. Okay. So, just try to remember both the things. Next question. Which of the following is or included in the directive principles of state policy? So, the question again is about the directive principles of state policy. Prohibition of traffic in human being and forced labor. No, this is related to the fundamental right. So, this is there in Article 23 of the Constitution. So, you should know what is a fundamental right and what is a fundamental duty. Prohibition of consumption except for medicinal purposes of intoxicating drinks and other drugs which are injurious to health. So, this is very much true. So, this is a Gandhian principle which is there under the directive principles of state policy. So, this is true. So, the right answer would be option 2 only. Which of the statements given above are true? So, that would be option 2, that is option B only. So, it is very, very important that you understand these things. So, please understand, very, very simple questions are asked from this philosophical part. So, you will have to basically understand the various fundamental rights. You should have a conceptual understanding of these fundamental rights. You should have the good idea as to what these words like liberty, justice, equality means, and then you should have the ideas of the fundamental duties and the other things. So, quickly we will move to the next question. So, I think 2 to 3 questions or more, we will just complete them before we wind up the today's class. So, this is an exceptional question, but sometimes they can ask you such questions as well. So, what is this question is about? Consider the following statements in respect of Bharat Ratna and the Padma Awards. Now, statement 1 is saying the Bharat Ratna and the Padma Awards are titles. Now, under Article 18 of the Constitution, giving titles by the state is prohibited. And or the Bharat Ratna and the Padma Awards, there are 3 Padma Awards in our country, that is Padma Bhushan, before that Padma Vibhushan, Padma Bhushan and Padma Shri. And then you have the Bharat Ratna, which is the highest civilian award. The Bharat Ratna and the Padma Awards are titles under Article 18 Class 1 of the Constitution of India. The Supreme Court has very categorically said that the Bharat Ratna and the Padma Awards will not amount to titles, they are merely awards. And they are given to the individuals who have done exceptional service to our country, and hence they cannot be considered to be titles. Okay, so they are not titles. So, this has been held by the Supreme Court in a case which is called as the Balaji Raghavan case. The case name may not be very important, but you can just remember this Balaji Raghavan case. So, the first statement would be wrong. Statement 2, the Padma Awards were instituted in the year 1954, so that is true. Were suspended only once? No. In fact, the Padma Awards were suspended 3 times in the history of India after it was instituted. 1978 first time, 1979 second time, and after 1978 and 1979, from 1993 to 1997, it was again suspended. So, it was suspended thrice in the history of India. So, this particular statement would be wrong. So, every year the awards are given during the Republic Day, and the Prime Minister usually constitutes a committee, and the committee of members will recommend the names to the Prime Minister, and subsequently these awards are given to them. The number of Bharat Ratna awards is restricted to a maximum of 5 in a given year. The number of Bharat Ratna as per the present rule can be subject to a maximum of 3 in a given year. So, which of the statements given above are correct? So, which of the following statement is not correct? Sorry, it is not correct. So, all the 3 statements are in fact not correct. So, the right answer would be option 1, 2 and 3 only. Let me just check it once again. Bharat Ratna and Padma awards are titles under Article 18 class 1. So, they are not titles, they are merely awards. So, this particular statement is wrong. And statement 2, they have been suspended thrice. So, once is definitely wrong. The number of Bharat Ratna awards is restricted to a maximum of 5. No, it is restricted to a maximum of 3 as per the present rule. So, that is also wrong. So, the answer would be option D. Come, let's move to the next question. Come to the next question. A very good question. With reference to India, consider the following statements. Now, the statement 1 says judicial custody means the accused is in the custody of the concerned magistrate and such accused is locked up in the police station and not in jail. So, for which we will have to understand something as to what is punitive detention. So, we already explained very elaborately as to what is punitive detention and what is preventive detention in the 100 most important topics in polity for prelims 2023. You may refer to those videos also. But however, here let me give a brief idea. So, whenever an individual is arrested by the police have to produce them before the nearest magistrate within a period of 24 hours. So, within how much time he has to be produced to the nearest magistrate? He has to be produced within the nearest magistrate within a period of 24 hours. And after this, so probably if the police needs more times for investigation and the offence is a serious offence, then they ask for more time for investigation. So, under such a case, the magistrate may place the individual in what is called as the judicial custody. So, this is exactly what is called as judicial custody. So, in judicial custody, where the individual is placed, he is in judicial custody. So, that would help the police officer to investigate the case further. Please understand, the individual is not yet found guilty in a court of law. He can be considered to be under trial. So, the investigation is yet to happen, and for this investigation, he may be placed for some time in judicial custody. And during the judicial custody, the individual is kept where? The individual is kept in prison, and he is not kept in the, or he is kept in the jail rather. He is kept in jail and he is not kept in the police station. So, this particular statement is wrong because it is saying that it is partially right. It is under the control of the magistrate, but he is kept in jail but not in police station. And what is the idea behind this? Why he is kept in judicial custody? That would help the police officer to investigate the case further. And whenever an individual, please understand, whenever an individual is placed in the judicial custody, the police officer concerned can investigate the individual only based on the permission that is given by the magistrate, not on his own. Okay. So, this is a kind of protection of the individual, so that the individual is not harassed or tortured by the police in the name of investigation. Come to statement number 2. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. So, this is true. So, which of the statements given above are correct? So, the right statement is only option B, that is 2 only. It is a very, very important topic to understand as to what is punitive detention, how it happens, who is under trial, what is preventive detention. To get more information and to know more about this particular topic, you may look into the videos of the 100 most important topics for prelims 2023, where we have dealt elaborately with regard to as to what is a preventive detention and what is a punitive detention and what exactly is the difference between them, how exactly the rights vary in terms of punitive as well as the preventive detention. Okay. So, we'll move to the last question for today's discussion. So, come to this particular question. With reference to India, consider the following statements. So, this statement is talking about the parole which is given to the convicts who are in prison. Statement 1, when a prisoner makes a sufficient case for parole. So, first we will have to understand as to what is parole. I will just come back to this particular area. When a prisoner makes a sufficient case for parole cannot be denied to such a person because it becomes a matter of his or her right. So, we will have to understand as to what is parole. Parole means an individual, a person who is in prison, who is convicted in a court of law, who is in prison, who is sent outside on, who is sent to his home, or he is sent outside the prison on condition. On condition, he is sent outside. What is the condition due to which he is sent outside? This is because of certain cases where there is a function in his particular home, or is just that there is a marriage that is going to happen to that particular individual. So, on certain conditions, when there is a need, he may be sent outside of the jail or to attend the marriages of others in the society. So, on condition, he may be sent outside. But however, please understand, asking for parole and getting parole is not a matter of right of a convict. The parole is granted by the state depending upon the behavior of that particular individual, but it is not a matter of right. Even if he makes out a sufficient case, still parole can be denied by the government or by the state authorities, provided if they feel that releasing or letting out this particular convict outside may be a grave danger to the society. If they feel that there is a danger, then they can deny this, and it is not a matter of right of the convict. Okay. So, this particular statement is wrong, because it is saying that if he makes out a sufficient case, it shall be a matter of his right. No, it is not a matter of his right. It is at the discretion of the state authorities, the prison authorities. Statement 2. The state government have their own prison release on parole rules. Do the state government have their own rules, or they have a centralized rules for all those things? So, that should be a very clear question and clear understanding in your mind. Now, please understand, prisons are an item in the state list. It is under the state list of the Schedule 7 of the Constitution. So, it is definitely what? It is definitely not a right of an individual, and it is also not definitely there is a central rules or a uniform rules throughout the country, and the rules has to be formulated by whom? The rules has to be formulated by the state government concerned. So, this particular statement is true, while this is wrong. So, which of the statements given above are correct? The correct answer would be option B only, that is 2 only. So, please understand, we have solved 45 questions including our class 1 and this particular class, and these 45 questions were related to the philosophical part of the Constitution. It is covered from the topics of fundamental right, fundamental duties, directive principles of state policy, and the preamble to the Constitution of India. Very simple, you can get all the 100% of the questions right. So, it is very important that you revise your polity, and after revising your polity, you watch these videos, and before going to the examination, your confidence can be really high, and whatever gaps in your understanding can be fulfilled in case of you look into these videos. And in case of any queries, you can also put it in the comments so that I can address the queries that you may have in your mind. So, keep watching all these videos. In the next class, we will continue with the next set of video, which is related to the system of governments. So, let me check how many questions are there in the system of governments. If there are not much questions from the system of governments, which is from topic like parliamentary system, federal political system, separation of powers, and once we are done with that, in the next class, we will also continue with the executive part. Okay. So, in this way, we will try to cover all these 7-8 topics for the last 15 years. Watch these videos, and you can also watch the 100 important topics. So, definitely it will benefit you in the preliminary examination. All the very best. Keep watching. God bless. Thank you very much.